How do I request a hearing before an administrative law judge? If you do not agree with a reconsideration decision made by Social Security, you may request a hearing before an administrative law judge, ALJ. You must appeal within 65 days from the date you got the reconsideration decision. Be sure to keep a copy of your request and proof of submission for your records. To request a hearing, you should complete the online form to request a disability hearing at ssa.gov or a non-disability hearing if your issue is with a termination or overpayment issue, also at ssa.gov. Alternatively, you can complete a Form HA-501, Request for Hearing by Administrative Law Judge, and submit it to your local Social Security office by fax, mail, or in person. Find your local office by zip code at ssa.gov. Additional forms for disability hearing requests. If you are requesting a hearing on the denial of a claim for disability benefits, you must complete and sign additional forms. These forms are SSA-3441 Disability Report Appeal and SSA-827 Authorization to Disclose Information to Social Security, SSA-1696 Appointment of Representative. If you are appointing a representative, your representative should also sign this form. If you are unsure of which forms to complete, call your local Social Security office and the staff there will guide you on which forms to complete. How do I prepare for my hearing? The most important thing you can do for your case is to request all your medical records and submit them to the hearing office. Even strong cases can be denied if the judge does not get all the medical records. Keep in mind that medical records can sometimes take 2 to 3 months to gather, so be sure to make the request as soon as you request the hearing. Typically, the records department at your doctor's office or clinic will have the records you'll need. Some examples of records to request from your medical provider include outpatient treatment records, lab reports, x-rays, and MRIs, physical therapy and pain management records, psychiatric and therapy records, and inpatient and ER records. In New York State, by law, your doctors cannot charge you money for copies of medical records if they will be used for an SSI or SSD claim or appeal. If your doctor has these records in electronic form, you can ask for the records on a CD or in some other electronic form. See www.health.ny.gov. There may be other records you could provide. These can include letters from prior employers regarding work accommodations they gave you, letters from family members regarding your symptoms, lifestyle changes, and any assistance they give you, such as with shopping, laundry, and making meals. School records like IEPs, psychosocial assessments, speech and language records, IQ test results, and other testing results. You must submit your evidence or inform Social Security's Office of Hearing Operations, OHO, about any missing evidence at least 5 business days before the hearing. Unless an exception applies, the judge may refuse to consider evidence submitted later. Also, you should tell the hearing office about any new treatment, new doctors, work activity, and other changes in your case. If you don't keep Social Security updated, then the judge might refuse to look at these records at the hearing. If you want the judge to request records that you cannot get, you can ask for a subpoena. A subpoena is a court order that would force another party to provide evidence at your hearing. Subpoenas must be requested in writing at least 10 business days before the hearing date. For more information about subpoena requests, the contact information for OHO can be found here at www.ssa.gov. How is the hearing conducted? Do I have to appear in person? Social Security will mail you a hearing notice at least 75 days before the hearing, unless you agree to waive, give up your rights to, this advance notice. Before you sign anything that gives up your rights, consider the consequences. If you need more time to request your medical records or to find an attorney, you might not want to waive your right to a 75-day notice. Social Security usually schedules hearings within 75 miles of your home. In certain situations, your hearing may be held via phone, video conference, or in person at a hearing office. You do not have to accept a video or phone hearing. It is your right to request an in-person hearing. What if the ALJ denies my claim? What's next? If you disagree with the hearing decision, you may request a review by Social Security's Appeals Council. The same request is used for disability or non-disability claims. You can file the request online at ssa.gov, or you can file the paper form by fax, mail, or in person within 65 days of the judge's decision. The Appeals Council reviews each request, but it may deny a request if it finds the judge did not make a mistake. If the Appeals Council decides to review your case, it will either decide your case itself or return it to the judge for further review. How can I find a representative to help me with my case or a lawyer to help me with my appeal? If you live in New York City, call Legal Services of NYC at 917-661-4500 or the New York Legal Assistance Group at 212-613-5000. Visit us online at lsnyc.org or nylag.org. If you live outside of New York City, contact your nearest Legal Services Corporation provider. Visit lsc.gov or lawhelp.org to find a provider near you.